Case number 1. Herb continuously teased Carol, who was overweight. She could hear him say, "Waddle, waddle," when other overweight women walked around the office. Herb mimicked the swishing sound of her nylons rubbing together because of weight and called Carol and another woman the Fridge Sisters. The question for you to answer, is this sexual harassment? Well, I'd say yes. Put-downs like these are of a sexual nature because women have to endure issues of weight more than men. This employee is finding a way of hurting this woman's feelings, and that will clearly have a damaging impact on her work. Or I'd say no. While these comments are rude, there is nothing sexual about weight. Men are just as hurt by comments about their weight, and weight or appearance are not protected grounds under human rights law. So the question for you to answer, is this sexual harassment, yes or no? You've got 3 minutes to decide. Okay, so we've got 11 of you, 11 of the tables who have said yes, 34 who have said no. All right, now, if there's the opportunity, and there's a mic there, mic number 1, mic number 2.
Because he was targeting one specific gender, so that would meet the criteria of sexual harassment.
That even though some of the individual comments may have been sexual in nature, the comments as a whole, because he included stuff about waddling, etc., which could be referred to either sex, so that the comments as a whole, if you looked at the whole picture, it was non-sexual in nature.
Okay, all right. So this case is Carol Shaw versus Levac Supply Limited, a decision of the Ontario Human Rights Commission from 1990. And it's one of those things in which you're thinking, yeah, Stephen, aren't you being sort of cheap or lazy that you're giving us a decision way back then? In Canada, only courts can set precedents. But when you have human rights adjudications in the same way as arbitrations, is they're given a lot of importance. Like someone will bring something forward, like Deb or some of the other labor relations officers will actually bring something forward and say, a case was decided like this, and we think it's got persuasion of some kind. This case was never overturned by a court, so it's still one that when something similar like this comes up, you will find that lawyers or representatives will use it again. Basically what happened was Herb Robertson was working with Carol Shaw for about 14 years. And she was putting up with these comments on a regular basis. She goes to Roger Levac, the owner of the company, and asks him to do something, and he didn't think it was a big deal, so he didn't do anything. So after all those years she left, she went to the Ontario Human Rights Commission, and she made a complaint of sexual harassment. Now, just like the 34 tables who thought this was not sexual harassment, Levac Supply Limited made their argument to say, look, if in fact this was bad behavior, and we'll admit that it was, it is not part of your jurisdiction because it has nothing to do with sex. And issues of appearance or weight on their own are not protected grounds. Weight sometimes can come into a category if, let's say, I think that someone is so overweight that I think it's going to be an inability for them to do their job, and therefore in my mind, I might think of it as a disability. I mean, in the front of my mind, I'm not, but the courts and tribunals have actually said it's like he thinks that person can't do that job. It's like he thinks the person has a disability. So that's only when, or that's usually when issues of weight will actually turn up in something like human rights. But once again, the whole view it would be on disability. So they're just saying, look, this isn't about sex. So they went through the any chance of trying to settle the case, and that didn't work. So it goes to a full hearing, a full adjudication. And the adjudicator came up with 2 reasons for his decision. Comments. If what you do is you single out a group of people based on one of the protected grounds, in this case sex or gender, then that's considered discrimination. So whether it's harassment or just blatant, sort of direct discrimination, that would be a form of discrimination based on sex. The other part was very controversial, and I want to be very clear, and I want to explain when I say it, because I don't want to give the misinterpretation, even speaking for the adjudicator in this case on what he had to say. What he was talking about was the relentless comments that she and other women were having to put up with. And there's lots of times where people can say, you can say what you want about me, I got good self-esteem, I can put up with this. But the fact is, on a regular basis, he was saying this, and it's got to wear down the best of us on our best days in order to think highly of ourselves. So this is what he said, and I'd like to read it verbatim. It seems to be incontestable that to express or imply sexual unattractiveness is to make a comment of a sexual nature. Whether the harasser says you are attractive and I want to have sex with you, or says you are unattractive and no one is likely to want to have sex with you, the reference is sexual. It is verbal conduct of a sexual nature, and it is sexual harassment in the workplace if it is repetitive. And a little aside on this, it doesn't always have to be repetitive. But he says if it was repetitive and has the effect of creating an offensive working environment, it is sexual harassment in the form of an inappropriate comment of a sexual nature. And I want to be very clear, he's not saying that if you're overweight, you're sexually unattractive. He's saying that a person could feel a lot less about themselves and start feeling as though they're unattractive because of these very mean and demeaning comments that were being made. In the end, Carol Shaw was awarded $43,000 in change for lost income and expenses and $5,000 for general damages. Herb Robertson, the co-worker, as well as Roger Levac, the owner, were found jointly liable for that particular award. So is this sexual harassment? The answer is yes. Congratulations to the 11 teams who got that correct.